Mr. Price.
So I'm intending to finish this afternoon, which is at 4 o'clock. I've got 3 topics to cover: the post-act authorities, Article 10, and distress damages.
Thank you.
Before I go to post-act authorities, I ought to mention, in terms of what happened in the Court of Appeal, that from our side the focus was very much on the authorities, because we felt we had a number of Court of Appeal decisions which were binding authority in our favour. Obviously, it's a different approach when we get to here, but it is interesting that one of the reasons for rejecting any sort of precedent value to the previous Court of Appeal decisions, according to the Court of Appeal in the present case, was that the point hadn't been argued. It just exactly shows how novel it is, such a departure it is from the existing jurisprudence. I'm going to go through the post-act authorities pretty much via my case. I will go to the judgments in Tinkler, Tesla and Sallows, and of course if there's anything specific that the court wishes me to go to, I will do that.
Thank you.
So I'm on page 77 of the bundle, which is page 17 of my case, paragraph 54. The relevant points when we go through these cases are the consistent admission of extrinsic facts in relation to Section 3, that negative likelihood of loss, and the conceptual challenges that would be faced if a tendency test was now adopted. The first case I want to go to is Tesla, which is the second one chronologically, the first one being Sallows and Griffiths. But Tesla, over the last 10 years, up until the Court of Appeal decision in the present case, has been the leading authority on Section 3. It can be found at page 366 of the bundle. As I mentioned, it's a top-gear review of the Tesla Roadster. The alleged falsehoods are set out in paragraph 7 on page 369. Essentially, that the car ran out of charge and there was a problem with the brakes. Just pausing there. Those imputations clearly satisfy a tendency test. But yet, as we'll see, the claim was struck out in part because there was no prospect of success on Section 3. Why was that? Because of the issues of causation that are referred to in paragraph 14 on page 371. The first is the previous broadcast. I've referred to that. And the second was the fact that it did run out of charge on the track. It was said, a true allegation in relation to the length of running of the battery, and also there was a problem with the brakes, as you can see from paragraph 15 in the middle. In fact, they hadn't failed. There was a fuse in the equipment providing power assistance to the brake pedal. So the previous broadcast, extrinsic facts, and true statements not complained of, intrinsic facts, and these give rise to issues of causation, plainly in relation to Section 3, and this need to separate out the actionable parts of the broadcast or publications complained of was a problem before the judge, and it wasn't properly particularised, ended up getting struck out, and an alternative version didn't pass muster. We come on to the court statements of principle in relation to Section 3 in paragraph 27 on page 375. And forgive me, I make all these submissions in the context of the Court of Appeal's treatment of this case, which was that it wasn't dealing with Section 3. It was only dealing with abuse of process. Start of paragraph 27, it's common ground the claimant can recover general damage as in section 3 of the Defamation Act if he can prove that the statement of which he complains is calculated, i.e. more likely than not, to cause him pecuniary damage. There's no appeal against the judge's decision that in this case, because of the problems of causation to which he referred, Tesla should be required to set out the nature of its case in some detail. So those problems of causation relate to the case on section 3. That was necessary to enable the CIC to understand the grounds on which Tesla alleged its statements on which it relied were more likely than not to cause it damage. If one moves... So the court here was effectively considering an application for permission to amend, but it was dealing with it on the basis of the merits. As is apparent from the bottom of paragraph 28, the last two sentences, which starts with, it must also have regard to the intrinsic merits of the case which the applicant seeks to raise. In paragraph 28, there's the requirement, the first sentence, set out the nature of the damage which is said each of the broadcasters was likely to cause, and the reason why Tesla was more likely than not to suffer damage of that kind. None of this would be totally unnecessary if we had a tendency test just on the tendency of the words. Paragraph 31. At the heart of the judge's concerns lay the question of causation. Following the original broadcast on the 14th of October, there were 27 repeat showings of the programme. And it continues, most of the damage must already have been done. And then, about 8 lines down, there's added to that is the potential for damage to have been caused by any unfavourable statements about the roadster that were admitted to be true. For example, the time required to recharge the battery as a consequence of overheating. Although for the purpose of a claim in section 3, it was not necessary for Tesla to identify how much damage had been caused by the action of forces, it was, for those reasons necessary in this case, for it to describe in general terms the nature and extent of the loss said to be likely to result from the publications which were subject of the action. And then the court accepts the criticism, or accepts that the case that the true or not complained of statements cancelled out those that were complained of was not sufficiently strong to result in amendment being refused. That's 35. It might be the second of those questions are largely well-founded, but just pausing there, it might fail on the facts, but it was clearly recognised as being an available argument for a defendant seeking to rebut a Section 3 case. And this is all being done within the constraints of Section 3. It's not being done on the basis of a rebuttable presumption. Continues at 36. However, in my view, Mr. Spearman's criticisms of the judge are nonetheless misplaced. So it doesn't matter about truth. The difficulty for Tesla is over a period of some 15 months between the first broadcast of the programme, December 2008, and the beginning of the one-year limitation period at the end of March 2010, there had been numerous further broadcasts. Even if the programme had contained no unfavourable but true statements about the road, the fact remains there had been a very wide publication of what must be assumed to be false statements that were no longer actionable. The need to distinguish their effect from that of the actionable falsehoods raises the issue of causation in an acute form. Another example here, this authority demonstrates what it was the practice of the court of taking into account extrinsic facts on causation in relation to Section 3. And then we have the passage about drawing inferences for the purpose of Section 3 that I've cited in my case at the beginning, and I took you through. It's in paragraph 37. It's 6-7 lines down. Since the claim is for general damages, it's unnecessary for the claimant to identify the amount of pecuniary loss, which said the forces were calculated to cause. All that is required in order to make the nature of the case clear is identification of the nature of the loss and the mechanism by which it's likely to be sustained. Then there's a statement about what happens in the ordinary course of events if derogatory statements are made about a commercial product, so that's the basis for the inference. I can see the court might find it likely that some potential customers would be deterred from buying a rose by the actionable statements, even though they hadn't been deterred by any of the non-actionable statements. And then Jamil abuse of process is brought in relation to that. He then moves to special damages, where there's the same causation issues, and states his conclusions on the claim for general damages, specifically section 3, at 47 on page 380. I can now return to deal finally with the claim under section 3 of the Defamation Act. If, as I think, the claim is adequately pleaded, so you've got your inference in principle up and running there, it may be said the permission to make the amendment should be given so the trial can decide whether the claim is made out, and if so, what is the appropriate award of damages. However, this is a case in which there are grave difficulties in identifying any pecuniary loss that the actual false statements were calculated to cause. In my view, the allegations in paragraph 9.55 and leading to support Tesla's case tend to emphasise that it's likely to be very difficult to play the court that the actual statements coming, as they did so long after the first showing of the film, were calculated to cause any significant loss. And then there's a reference to Jamil, but the final conclusion is at 49. Recorded the judge's finding in the second sentence. The first finding is in relation to abuse of process, and then it said he did so because he considered that Tesla had no real prospect of showing that the actionable forces were calculated to cause it any damage over and above that caused by the non-actionable statements. Then he says it's not an abuse of process in the ordinary sense of it, and the key concluding sentence is it follows, 4 lines up from the bottom, it follows I'm not persuaded the case which Tesla seeks to make by the proposed amendment has any real prospect of success. That must mean it's failing on section 3, or if successful, is likely to yield any benefit to Tesla that can justify the devotion of substantial resource in terms of cost and use of court resources that its determination requires. So clearly 2 bases for refusing the amendment, one of them which relates to causation on section 3, and just confirming that in paragraph 50, 4 lines from the bottom. Accordingly, if I were satisfied the claim had a real prospect of success, I would not refuse permission to amend on that ground, which is, I think, delay. So he's refused it on a failure on section 3.
Yes, your point, as I take it, is that this case is only explicable on the basis that the court will look at the surrounding circumstances when deciding whether the words were likely to cause damage.
Oh, yes. And Tinkler, which is the next one, is quite similar in terms of the start point, which was that an inference could in principle be drawn, but when you look at the circumstances, you see that it can't be. I'm going to go straight to the Court of Appeal decision. I think the Respondent's case refers to Mr. Justice Ninklin's, but one should see it in the Court of Appeal. They do pretty much follow what Mr. Justice Ninklin held at first instance. This was a case...
So which page?
It's 422.
422.
Yeah. This was an announcement to the stock exchange, which was critical of the claimant's management. Pausing there, that clearly satisfies a tendency test. But, in summary, it was only an early incident in a wider battle played out in public, with other previous and subsequent incidents much more likely to have caused pecuniary damage. So here the competing causes were not just prior to publication, as they were in Tesla, because the broadcast had taken place. Here the Court of Appeal took in events that had happened after publication and framed the test in a historic manner. Again, the Court of Appeal, in the present case here, said, well, they didn't make any finding on Section 3. This was all about abuse of process, but clearly that is not the case. And the Court of Appeal's judgment in the present case doesn't really engage with the admission of these facts. If one looks at the head note, one can see that a lot of the case was about relitigation. There's been a judgment which had made criticisms of the claimant's management in another context. But there was another discrete ground on which to strike out the malicious falsehood claim, which was in relation to Section 3.1, which is apparent from the last 4 lines of the head note. The malicious falsehood action was rightly struck out on the additional basis that it did not disclose a reasonable course of action, which meant the claimant had not in any event satisfied the requirements of Section 3.1 of the Defamation Act 1952. So when I go through this, I'm going to make clear that it's a substantive decision on Section 3.1, contrary to what the Court of Appeal says. You can see that point made in paragraph 2, where it's recorded that about halfway down, the second reason why the judge struck out the case was no properly arguable case on Section 3.1. And one can see from the chronology in paragraph 5 that the publication complained on was on the 29th of May, which is called the RNS announcement. And it followed an earlier RNS announcement on the 25th of May. Just pausing there, that was a highly relevant feature of causation in relation to Section 3. And then what happened, if one goes through the judgment, is that there was a judgment of Judge Russ and Queen's Counsel subsequently, which you can see from paragraph 7, found that Mr. Tinkler acted in serious breach of his fiduciary and contractual duties, and his dismissal as an employee and removal as a director had been lawful and valid. That decision gave rise to the relitigation abuse of process. Then the judge's findings, relevant ones, perhaps go to 429, which is paragraph 24. I think there had been citation of Tesla, but the same point about very real problems in relation to causation are referred to in the first paragraph of 24, extracting from 95. And then we have the same point about the drawing of inferences made in Tesla in the Court of Appeals, setting out a paragraph 94.3 from Mr. Justice Nickling's judgment. If the announcement had been the only thing of significance publicly to affect Mr. Tinkler, then an inferential case based on a drop-off of offers or directorships or investment opportunities might have had some prospect of success, but that was not the position. And then there's that sentence which I cited when I was just describing the case in general terms. The likelihood of the other damaging publications causing pecuniary damage, they're clearly admissible. Citation of Section 3.1 is in paragraph 36 on page 4, 3.1. Drawing a distinction between defamation and malicious falsehood. The malicious falsehood claimant is required to demonstrate that the publication caused him pecuniary damage, and then referring to Section 3.1 as obviating the need to prove special damage. 37, it says a claimant can therefore recover general damages by showing that the alleged false statements were calculated, which has been held to be more likely than not to cause pecuniary damage. And then there's the citation from Tesla. Moving through to paragraph 39. I should add that I've also in the case given the references for the relevant parts of this judgment. You can see from paragraph 6 of the grounds of appeal, which are cited in paragraph 39, that one of the grounds was that the evidence and submissions did support an inference that publication of the announcement was more likely than not to cause pecuniary damage to Mr. Tinkler. The submissions on that issue are made at 55 to 57. I don't think I need to go to them. You can just go to the conclusion in paragraph 76, page 438. You can see the heading is Conclusion on Reasonable Cause of Action, specific reference to Section 3 of the Defamation Act 1952. This issue gives rise to two questions. Are the sorts of losses claimed by Mr. Tinkler recoverable in principle? And second, so there was an issue about some of the categories of loss, but certainly the loss of directorships was recognised as a category of loss that could, in principle, be recoverable. The key question is the second one. Is there an arguable case that they were caused by the publication of the RNS announcement? And paragraph 81, as to causation, there's a reference to the competing causes. And in the light of them, there was no real prospect of succession in relation to Section 3. And then there is Sallows and Griffiths, which was an earlier decision. But I think it's possibly the first one that deals specifically with competing causes.
Are we moving on to another case?
Yeah, it's on page 344. It's called Sallows and Griffiths. It's a Court of Appeal decision again. Yeah, 334. It's a 334.
334.
Yeah, it's a 1999 decision. I'll just summarise the facts briefly. The plaintiff and the first defendant were directors of a company. The second defendant was a shareholder. The defendants sought to procure the plaintiff's removal from office by making trumped-up charges of dishonesty, which were communicated to him at a board meeting, also attended by the company's solicitor, at which he was dismissed. The malicious falsehood claim was based on publication to the solicitor and the company at the board meeting, and a further alleged publication to the personal assistant of one of the defendants. A separate claim against the company for wrongful dismissal was subsequently settled. So that's after the publication complained of. There's a settlement of the wrongful dismissal claim.
This case, unlike Tesla and Tinkler, is concerned with a much narrower publication.
Yes. It's not concerned so much with inferences. I rely on it for the general statement as to likelihood, because I'm fighting a tendency test here, and also because of the admission of the £5,000, sorry, the admission of the wrongful damages compensation. So the publication of the company failed, two reasons, one of which was that he'd received compensation or wrongful dismissal. How does that fact, that post-publication fact, fall within the tendency test? It can't be accommodated within it, and you can see that, with great respect, Lord Justice Warby didn't properly address it in the Court of Appeal's judgment. I accept that the tendency test could be relied on as a basis for rejecting the claim against the company's solicitor and the personal assistant, that they just weren't in a position to cause financial loss. But it's the statements of principle and also the admission of the wrongful dismissal damages which are relevant. The statement of principle is in paragraph 17 on page 338. I can just ask you to read that paragraph. It's a reference to in the circumstances in which they were made, you go beyond the words, and the need to show likely financial loss. You may remember I took you to a passage from Main and McGregor, not the one that was referring to inducement, comparing malicious falsehood to inducement of breach of contract, but the one talking about financial loss effectively remaining the gist of the tort. I said that sentence had been there right through every edition, but following this decision, this was cited as authority to support it, and that's been in Clark and Linsell, I think, probably for about a number of years. I'm going to come to the textbooks in their modern form when I finish the review of the authorities, and you can see that that's cited. Clearly, the wrongful dismissal damages were one of the reasons why the claim in relation to the company failed. I accept it may be artificial to say there'd been publication to a company when there'd been no individual, but why shouldn't the wrongful dismissal damages be taken into account? Why shouldn't you just look at the end of the day and see whether the claimant has in fact been compensated for the loss? How did the Court of Appeal deal with this? Paragraph, I think I'll go to this if I may. It's a paragraph 58 on page 167.
What page did you say?
I think you gave us the wrong page.
We're on paragraph 58.
Page 167. Paragraph 58 on page 167.
Well, I'm on 339 on paragraph
This is
18.
the Court of Appeal's judgment in this case you're talking about?
Yeah.
Yes.
So how the Court of Appeal dealt with
sorry.
in this case. Yes, this is how the Court of Appeal dealt with.
Oh, I'm sorry.
So I'm sorry if I'm not being clear on this. Forgive me. It's
Paragraph.
Surprise, could you speak a bit more loudly
Yeah.
and clearly?
I'm sorry,
It's
yeah.
not always easy to pick up.
Yeah, I'm very sorry.
So you're now going to a different judgment.
We're
No, I'm showing how the Court of
A
Appeal.
judgment in our case.
Yes.
Sorry.
Yes, how the Court of Appeal analysed Sallows.
Yes, because in
And
paragraph
my point is
58
they didn't really deal with
yeah.
the gravamen of it. Paragraph 58 cites from the judgment, recorded the damage from the wrongful dismissal claim being taken into account, and then 5 lines up from the bottom, the words I have emphasised do not support the defendant's case. They reflect the interpretation I would favour. I would analyse this case. This is a case in which the claimant failed to discharge the burden of pleading and proving a basis for concluding that it was inherently likely at the time of the offending publication would cause him pecuniary loss that he'd not already been compensated for. Well, he was compensated for it afterwards. So it seems to be recognising that the compensation can be taken into account, thereby admitting an extrinsic factor on causation that's not covered by the tendency test that was formulated by the Court of Appeal, which focuses on the identity and essential characteristics of the claimant.
I'm finding that last sentence a bit difficult to follow. What is the time that Lord Justice Warby is actually identifying?
Well, you would think it was at the time of publication because
Well, it doesn't say that. Well, I mean, that's maybe what he meant, but that's not what he says, and that's why I'm just raising the question.
Yeah, well, if it's...
It seems to refer to the time that the offending publication would cause him pecuniary loss.
No, I think he's saying that at the time, it was inherently like at the time. Oh, I see. Yes.
Yeah.
Well,
Does he mean at the time of the offending publication?
I think
do we
so.
think?
I think so. She's referring back to his earlier statement.
I see. All right.
But how can that be?
Yes.
So the problem is, if he's referring to the time of publication, then
The compensation hadn't yet been paid.
yes.
Yeah.
And if he's referring to having afterwards, then it's not only it's not a tendency test, it's also a historic test, because you're looking at the position at trial and applying the but-for test on the basis of all the circumstances prevailing at trial.
He switches time, doesn't he? In effect, in mid-sentence.
Yeah. So he switches time mid-sentence, and with great respect, he's plainly wrong to say that Tesla and Tinkler are not directly engaging with the viability of the Section 3 case, and not plainly recognising that extrinsic facts need to be taken into account. I now move on to other Court of Appeal decisions. I propose to take these through my case. I'm on page 81 of the bundle, paragraph 71 of the case. Of course, I'll go to any authority if the court wishes me to do so. The Court of Appeal's judgment in the present case referred to 3 other Court of Appeal decisions. In my submission, they're not really very helpful on the specific issue that we've got to deal with here, which is the admissibility of extrinsic facts and competing causes. First case that was referred to, in fact the first case in time, is Calvert and Tomkis. And really, this is a case which is just based on the narrow allegation. It's based on the pleading, which was simply that it's a newspaper article saying that the claimant found Hollywood to be an awful place. She was an actress. She said this was harmful for her as an actress, and she didn't say the words. And the only averment was simply that it was calculated to cause pecuniary damage. And so the whole issue about disclosure and what evidence could or could not be given at trial just turned on that very narrow averment. There was no question of the defendant seeking to introduce competing causes. There's references to actual loss and proving actual loss, and these are all capable of being understood to mean special damages.
But in the Calvert case, the Court of Appeal upheld a judgment refusing the defendants any disclosure.
Yes, on the basis of the narrow issue on the pleading.
But you know, if the defendant is entitled to argue that in all the circumstances there was no loss,
that burden would fall on the defendant.
yes, but would they not be entitled to disclosure?
Well, they'd have, in accordance with ordinary principles, you don't get disclosure until you've pleaded your case. So
Yes.
you'd have to plead your case and then ask for the disclosure on the back of that pleaded case, and there's no evidence that
So
there was.
in this case, that no such case was pleaded.
No, and it doesn't appear from the facts that there was any sort of obvious competing causes you can see in Tesla, Tinkler and Sallows. So it's just an application of the ordinary principles of disclosure to what happens to be pleaded in the case. I can go to the case.
I've looked at it.
I'm grateful.
But so you say it can be understood in the context of what must have been pleaded or wasn't pleaded.
Yes.
Because on your case, if the defendant in that case had said that the actress didn't get work for a period of time because she'd broken her leg or something, then the defendant presumably in your case would be entitled to the hospital records to vouch the broken leg.
Yes, I mean, there's obviously the question of whether we're treating this within Section 3, because all these cases are treating the inquiry within Section 3, or whether we're treating it as a rebuttable presumption, in which case the defendant would have to raise it before it became an issue. But I mean, I think if you look at Tesla and Tinkler, there are obvious causation issues that present themselves, and I think technically the expectation was that the claimant would have to deal with that, because it was all being debated within the framework of Section 3, where the burden lies on the claimant. So these issues arose, presumably they arose because the defendants mentioned them as being obviously relevant. In Calvert, we don't see that. We just see a newspaper article that makes an allegation, which you think, if you want to work in Hollywood, could be damaging for the plaintiff actress, and then simply an averment of likely loss, which wouldn't give rise to, certainly wouldn't, the disclosure sought in that case, I think, was previous accounts, and that wouldn't flow from the particular allegation that was made, and maybe not even necessary. I mean, why would it be necessary for a claimant who relies just on a pure inference on the basis of Section 3 to disclose previous accounts?
No, the claimant's case would not require it on your case and on your opponent's case.
Yes.
The claimant's case wouldn't require it. The only question that, in my mind, was if the defendant made an issue of causation.
Yes, that's.
We don't see in the report whether or not the defendant did.
None of these cases was the defendant making an issue on causation, on liability, certainly. And one shouldn't be too influenced by references to actual damage and think that proving actual damage is the equivalent to inferring an unquantifiable loss, because it's not. That's really the difference that we saw when we looked at the approach of the courts in relation to malicious falsehood prior to the Act, and we compared it with the approach of the courts in relation to inducement of breach of contract. The next case... How
in a case like Calvert would the court quantify her damages without having evidence as to what she'd earned?
Well, I suppose it's a... I don't know. I mean, it's a fair question.
She might have... Well, quite.
I mean, it was all pretty speculative. I mean, Lord Denning didn't really close off any line of inquiry at the retrial. I mean, my main point is it doesn't really help you deal with the issue that you've got to deal with today.
Well, given we don't know what the defendant, what if anything, the defendant put in issue in Calvert, then it doesn't really help us.
Yes. The next one is Fielding. Here, the defining feature was that there was, it's Fielding and Variety, 1967 decision of the Court of Appeal. Here, it was default judgment. So the submissions on the likelihood of loss took place within an argument about damages, and the judge in this case noted that and didn't find it of particular assistance because it's very far away from the facts of the present case. It wasn't directed to the proper interpretation of Section 3. It didn't have to take into account competing causes. It didn't have to address liability. So unless I need to go to that case, I'm going to move on to Joyce. I suppose I can deal with it in reply if it's felt that I need to. So Joyce and Sen Gupta, a 1993 decision of the Court of Appeal, leading judgment of Sir Donald Nichols, Vice-Chancellor. We're going to need to look at this one in relation to distress damages. I rely on it for my submissions on that issue. But there's really not very much there that's relevant to this issue because the court wasn't dealing with it. I mean, this was an article in a national newspaper which accused the plaintiff of betraying the confidences of a member of the royal family for whom she worked. So there's obviously there a potential for it to impact on her employability, and it was an interim strikeout by the defendant primarily on the basis that this was a libel case in disguise, and the plaintiff should not be allowed to pursue it with legal aid. When there was no legal aid for libel, that argument failed. The Court of Appeal refers to passages there. The Court of Appeal in the present case, I should say, refers to passages there about relieving a plaintiff from proving damage. I make the point I made before, that's just all explicable in the context of special damage. I'm now on page 82 of the bundle, which is page 22 of my case, paragraph 77. I'm dealing with another conceptual challenge for the tendency test. It's those cases which fail due to the likely verification by the publishee. It's sufficient under the tendency test that the imputation complained of, if it's true, has a tendency to cause a publishee to act in a particular way with the potential to cause harm to the claimant. The test doesn't accommodate the likely impact of publication of the imputation in reality. And a specific element of that is the likelihood of the publishee seeking to ascertain its truth or falsity before taking any action. And now, a number of cases have failed on this basis. The first is Stuart Brady in Express Newspapers. 1997 decision involving the Moors murderer. And the allegation was that he'd attacked, I think, a female visitor, and that this could result in him losing some form of allowance or compensation for work that he did. This was held to be, in principle, a recoverable loss for the purposes of malicious falsehood. But the issue was that the hospital would not have acted on a newspaper article alone. It would have conducted an inquiry. And so the loss it was caused would have been as a result of the inquiry establishing that the allegation was true, not the newspaper article, even if that had been the prime cause of the matter coming to the attention of the prison, or the hospital, rather. It's also fair to say that that case, which is the first instance decision of Mr. Justice Morland, contains an explicit statement that the test is forward-looking and that you do not consider any circumstances, or any facts, I should say, after publication. You can take into account the likely reaction, but you don't take into account what the hospital actually did. Then I refer to Must Holdings and Astra Asset Management UK Limited, first instance decision of Mr. Justice Friedman, which is, I suppose, closer to the facts of this case. This was a substantial commercial claim brought by Must, and Astra responded with a counterclaim relating to a conversation that a Must employee had with a potential investor of Astra, which had, I think, suggested that they were in financial difficulty and that they weren't a good bet for an investment. And referring to Stuart Brady, the Section 3 claim was rejected on the basis that the investor, assuming he's wanting to do business with the company, and if he doesn't want to do business with the company, there's not been any loss, he would have asked the company about it, and he would have found out very quickly that it was untrue. Clearly, the suggestion that the company was going potentially bust made to a potential investor would satisfy the tendency test. But
are you going to show us the crux of the decision?
I can do, yes. So it's on, the crux of the decision is on page 1227.
It is paragraph 631.
631 and 632, yes. Now, that's said in the context of defamation claim and serious harm, but the same reasoning applied to malicious falsehood. And you'll see there that it's the Stuart Brady case that I just mentioned, that was cited there. But
so is this is the trial, is it?
yes,
Why were they speculating about what would happen when you could read the book at this stage?
I accept that some of these cases proceed on a forward-looking test. But
were there any findings about whether it did actually check the position, or?
I think it didn't. I think I'm just trying to. So the publications complained of are, I think, set out paragraph 18 on page 1217. There's a claim in libel and there's a claim in malicious falsehood in relation to those publications. You can see from paragraph 29 that there's an issue raised in relation to serious harm for the purposes of defamation. And paragraph 30, it said that much the same applies to the claim brought in malicious falsehood. And I don't think there's, it's a very long judgment, but not very much on this counterclaim. At the moment, perhaps I can ask Mr. Jonathan Price to look into. I don't actually know whether there was a finding of fact that the potential investor did go to the company, did ask the company whether this was all true, and was told that it wasn't, was satisfied, as we have in this case. The facts of the present case are much stronger because it didn't require Mr. Lingenfelder to do anything to verify, because the respondent was on her way to see him with a demonstration of falsity that required.
I'm just not sure what your reliance on these authorities, how these help you, because in the tendency test, if you apply that, you do take into account, don't you, how a reasonable person in the position of the publishing would act.
No, I mean, no, certainly not in defamation. And as the tendency test was applied in the present case, there was no consideration of, well,
I mean, Mr. Lingenfelder actually having a copy of the contract of employment is a different case from whether a hospital would act on a newspaper report.
Yeah, but
that is forward-looking. Is it likely that the hospital would act on the report?
Yes.
Answer no, therefore
yes.
Not likely, not calculated to cause loss.
But my submission is that it's hard for the tendency test to take this into account because it's just focusing on the inherent likelihood rather than
inherent likelihood of these words on the particular category of publishee.
Well, I think it's the notion of inherent as opposed to.
Yes. As I understand your presentation of the tendency test, you think that the case you have to answer is that you look only to the tendency of the words and disregard the surrounding circumstances.
Well, that's certainly the case. Well, there's a number of, there's the admissibility of surrounding circumstances, and there's also it proceeds on the basis that the publishee believes the words and will act on them.
Even though one would expect a publishee in that position not just to rely on the words.
Yes, because it's about the notion of...
the Court of Appeal held in this case?
Well, it must do. I mean, we don't it wasn't exactly clear as to why it rejected the three key facts on
Well,
which...
Lingenfelder, because looking at it objectively at the time of publication, there's nothing... I mean, it would require a finding of fact that someone in the position of Mr. Lingenfelder would, first of all, require to see the contract of employment. Was that a finding that the judge was invited to make?
No, because he found that he saw it 2 minutes afterwards.
Yeah, well, that depends on the test you apply.
Yes. Well, I understand, but okay, so I raised by Respondent's notice in the Court of Appeal that the facts existing at the time of publication would mean that if you applied a forward-looking test, it would inevitably mean that it was not likely, as at the date of publication, that financial loss would be caused. One of those reasons being that Lingenfelder was about to find out.
All I'm wondering, because I simply don't understand how these authorities particularly help you in relation to Mr. Lingenfelder, that's the point. Or indeed Mr. Butler, for that matter.
Well, yes, I mean, I don't... these are within my submissions as to...
This is your alternative case that you're on. Or your first alternative.
Well, it's the problems with the tendency test. It doesn't really accommodate the reality.
But your primary position, as I understand it, is that one doesn't stop the clock at the date of publication.
Yes.
One actually looks at the whole circumstances and see whether, given everything we know, whether it's likely or not.
As I said, I'm here to try to help.
Refer us to paragraphs 631, 632, which was in the context of, I think, a discussion of defamation.
Yes.
But I think for completeness, you should also refer us to 640,
Yes, yeah.
which says it appears from the Tesla test that due to Section 3 of the 1952 Act, there's no difference, and the claim for malicious falsehood must fail due to an inability to prove either actual loss or that the words were calculated to cause loss. So you're saying that the issue of causation in this case that you're citing was very live, both in relation to both defamation and malicious falsehood.
I mean, I'll have a look at it overnight, but it seems from that paragraph that the judge found that there wasn't any actual loss because presumably the investor found out the true position or for some other reason. And then the calculated, why it wasn't calculated, you can see that links back to, sorry, I just put the case away, let me just get it back up again. So the finding in 640 that it wasn't calculated to cause loss in the sense that pecuniary damage was more likely than not to be caused by the publication, so that's a forward-looking test. That goes back to paragraph 631, and what a reasonable, the natural and probable consequence, what a reasonable person in the position of the publisher would have done.
Yes, I merely referred to it to say that it was bringing the reasoning of 631 and 632 into malicious falsehood.
Yes.
Yes.
But that's not on your primary case at least, that's a misreading of the Tesla case.
Well, I think the Tesla case is probably forward-looking in the way that the statements of principle were framed. Calculated means likely, and I think there is... I mean, I think it's probably on balance a forward-looking test at the date of publication, taking into account all relevant factors. But what didn't present itself there was a relevant post-publication event, and it's whereas Tinkler presented a relevant post-publication event, Sallows presented a relevant post-publication event, and therefore I don't think one needs to read too much into exactly whether it's forward-looking or historic. The relevant point...
It didn't matter in Tesla.
Yes, one has to just take in the probative facts on causation consistent with the basic compensatory principle and the nature of the tort. Unless I can be any assistance in relation to Mast Holdings, I'm going to move on to Phage. This is similar to Stuart Brady. It's a decision of Mr. Justice Briggs, as he then was. Again, it's a commercial case where the malicious falsehood arises by way of counterclaim. It seemed quite a common feature here that people facing heavyweight commercial litigation where they're looking like they're going to lose, bung in a malicious falsehood claim, perhaps for tactical reasons. This was a dispute about Greek yogurt. and the publication complained of in the malicious falsehood claim was to Camden Trading standards, asking them to investigate the defendant in relation to certain issues in their marketing, and conclusion was in relation to calculated that a regulator would not take steps likely to cause damage to a business without first conducting some investigation. And it's made clear that it's the conduct which has got to cause the loss, the conduct being the act of publication. I cited that passage from the judgment earlier on in my case. It's dealt with fairly briefly. If it would assist, I can go to the report. But it's just another example of what I submit, rightly or wrongly on this issue, is that the departure between the tendency test as it's commonly understood in defamation and the reality of loss in practice. Because if this court had been applying the likelihood of loss in practice, at the time of publication, it would have taken into account the fact that the respondent was on her way to sealing and failed with a contract. I mean, we don't need to consider the position in relation to Butler because he wasn't really a potential client. If I may, I'm now moving on to other causation issues, challenges for the tendency test. And this is in the context of the but-for principle. I'm now on page 83 of the bundle, page 23 of my case, paragraph 79. There's been a consistent enforcement of the but-for principle. We've seen examples of it in the previous cases. This originally derives from Agello and Worsley, an 1898 case. Admittedly, that was prior to the Act, and the respondent says, well, that's all to do with special damage. Perhaps if you just could read the facts as set out in that paragraph in 79 of my case, it's pretty straightforward. How does one deal with competing causes in a tendency test? Because it's focusing on the tendency of the words complained of, which is the words on which the action is founded. What happens if there are other words within the publication which are true or non-malicious and therefore not actionable, and which would have the effect of cancelling out any likely impact from the malicious and false imputation? How is that accommodated? I made the point in the Court of Appeal. You saw that it arose also in Tesla, where there were the true statements about problems with the vehicle. On the facts, it was held there was an arguable case that they wouldn't have cancelled out the false statements complained of. There's another case there, Niche, which was cited, where a similar point arose. The imputations in Niche clearly satisfied the tendency test, those ones complained of, but there was an issue in relation to ones they weren't complaining, and Mr. Justice Burst clearly took them into account as being admissible in relation to Section 3, but it was a strikeout application. And he held that, in common with Tesla, there was an arguable case that the false statements complained of would be the cause of some real proportion of likely lost sales, so that was left to go forward.
So which case are you now talking about?
This is Niche. I'm on paragraph 84 of the case. It's just a further example of the competing causes. How do you deal with these within the tendency test? They just can't be dealt with. They can't be addressed. The respondent's case doesn't address them, and the Court of Appeal didn't address them. There's there's no reference to niche products. Perhaps if we can just go to paragraph 60 and 62 from the Court of Appeal decision in the present case, we can see how they dealt with it in relation to Tesla. This is on page 168 of the bundle. The argument about the effect of the true statements is set out. And then it said in the penultimate sentence, thus the court agreed with Mr. Justice Tugendhat that the intrinsically damaging potential of the statements complained of failed to be assessed in the context of the broadcaster as a whole, but did not agree that this process led to the conclusion that the claim could not succeed. This is nothing to do with extrinsic factors. Well, why is that nothing to do with extrinsic factors? Because those words are not the words upon which the action is founded. So is the Court of Appeal saying that you do take into account words not complained of and look at the inherent tendency of those words and then compare them with the inherent tendency of the words that are complained of? I mean, perhaps that's theoretically possible, but there's a more fundamental issue that they didn't grapple with in my submission, which is the point that in order for the statements not to complained of to cancel out the, let's suppose, false and malicious statements, then they'd have to be true or at least made non-maliciously, and that would require an investigation that goes beyond the words. And what's said here at the bottom of paragraph 62, 5 lines from the bottom, a sentence starting, the defence also point to the fact that Tesla had admitted that the damaging statements of which it did complain were true, saying this is an intrinsic fact. So it is, but truth is logically irrelevant to analysis of potential causation. See nothing in the judgments of Mr. Justice Tugendhat or the Court of Appeal to suggest they adopted a different view. But it doesn't really meet the gravamen of my submission, which was, how do you accommodate the potential truth of these imputations not complained of within an inherently likely test? It's impossible to do so. It's another reason for just assessing the likelihood of loss in reality as at the date of trial. Perhaps my learned friend can assist on that, but I'm not really clear what the court is saying there, and I respectfully submit it's not an answer to the submission that I made, which is repeated in the case.
Just to put what I understand would be the case against you. The case against you is that what Section 3 has put into place is a tort actionable per se. So that all these problems that you are, in a sense, trying to deal with would only be questions that relate to what sort of loss you can actually get.
Yeah.
They're not denying that there is an actionable tort.
Yes. So the reason I'm drawing attention to all these cases is because, first of all, they illustrate how undesirable it would be to exclude competing causes, and secondly, because there's been a settled practice of the court taking into account competing causes that can't be reconciled with a tendency test that just focuses on the words complained of and provides an automatic remedy for any words.
But these cases don't tell us whether it was a matter of actionability or whether it was just a quantum matter.
Well, well, with respect, no, because Tesla was directed to the viability of the Section 3 case, and the truth of the statements were clearly relevant to the Section 3 case. And in niche products, they were directed to the viability of the Section 3 case as well. They weren't directed to damages. They were directed to whether the tort had been made out, and it was a strikeout application based on that.
Yes, I mean, your case is that these cases you're citing aren't directed to damages, they're directed to whether or not the Section 3 test of likelihood of damage was made out in the circumstances.
Yes. Well, I'm conscious of the fact I've got about another 15 minutes. I've got to do with two quite heavyweight topics.
We'll let you get on with them.
Thank you. I've referred to the citations from the textbooks, which are clearly recognising the admissibility of extrinsic facts and competing causes, pursuant to what I'm saying about settled practice. I don't need to repeat those. You can see them there. Right. I mean, Article 10. That's page 86 of paragraph 93 of my case. What is the case in a nutshell? It is that Article 10 is engaged in the interpretation of Section 3 of the Defamation Act. It is a restriction on freedom of expression that has been recognised in the cases that I have cited there. It's a restriction on freedom of expression because it allows liability to be imposed in certain circumstances, and it also allows proceedings to be brought, and that's increasingly in the era of SLAPs, which is strategic lawsuits against public participation, has been subject to parliamentary debate. It is a relevant factor. Tactical litigation where there's no loss. So there's a duty on this court to interpret Section 3, and indeed more generally the damage requirements in malicious falsehood, in a manner that is consistent with Article 10. And that necessity test means you don't impose liability in any circumstances, in my submission, where there's no countervailing right to be protected of the claimant. That's just an ordinary application of the proportionality test, which I'm sure this court will be familiar with. You look if there's an alternative way of addressing the mischief, which is less restrictive on freedom of expression. Article 10 works on a micro and a macro basis. You have to ask whether the particular initiation of proceedings and the particular imposition of liability is an unnecessary restriction on is unnecessary penalty or restriction on the particular defendant's Article 10 rights, and you have to take into account the effect on the free speech environment of laws restricting speech. That's well established in the Article 10 jurisprudence, which I can go to if necessary. So the question arises is, why is it necessary within the meaning of Article 10 for there to be liability in malicious falsehood? I would say absent proof of or inference of loss, absent there being any financial loss. What's the justification? If I had to make a second submission, I would say at least there has to be a likelihood in reality of loss as at the date of publication. But the tendency test, problem with the tendency test in terms of Article 10 is it inevitably permits a claimant to bring a claim as a matter of right where there's been no loss. That claim will constitute an interference with the rights of Article 10 right of the defendant, and there's no justification for it because there's no countervailing right, and there's no practical reason of policy for it. I mean, the common law defamation test, there were at least certain practical reasons for it in terms of ambit of evidence, simplicity, also reputation being a fundamental right, the need for vindication, all these. But there's nothing in the respondent's case and nothing in the Court of Appeal's judgment says, well, why is this a good idea? Why do we need this? It simply says, well, defendant's malicious, so don't worry about it. But that's not how the Article 10 jurisprudence works. And obviously, the ambit of this tort will affect people who are not malicious, and they get dragged into litigation. It's this approach to Article 10 which has given rise to the threshold of seriousness, which applies pretty much across all publication torts. It was referred to in the Bloomberg case, ZXC and Bloomberg, misuse of private information. It's referred to in Lloyd and Google, a data protection case. It was a principle established as far as the tendency test in defamation, and then was really taken into account by Parliament in passing the serious harm test. So, what is the minimum threshold of seriousness in a tort where the interest to be protected is economic loss? Well, it has to be the existence as a fact, possibly by inference, but as a fact of that economic loss. What right of a claimant is infringed by denying the claimant a cause of action, a right of access to the courts, if no loss has been caused? That was a question a submission I made rhetorically in the Court of Appeal, and there wasn't really an answer to it. The court tried to invoke protection of morals, which is really not the position if one looks at the jurisprudence on that issue, and certainly not the purpose of the law of tort, certainly an economic tort, to uphold morals. It talks about the Article 1, the protocol, rights of property, but they clearly require some financial loss to be engaged. That's the analysis. Any practical reason why we have to impose liability? No. I mean, the court just said, well, that's what Porter said, that's the wording of the statute, it's annual malicious, so we don't have to worry about that. It accepted the key principles about the initiation of proceedings as an interference. It accepted that there's a possible chilling effect on honest speech, but said, well, you have to prove malice and you have to prove falsity. And if you read the submissions by the media defence on this issue as to how things work in the coalface, in my submission, they are convincing. And if there's any risk of a chilling effect, then this court has a duty under Section 3 to take steps to avoid it.
A chilling effect on what?
A chilling effect on the exercise of speech on matters of public interest. It's about creating an environment. In terms of the chilling effect, let's just start, if I may, with the Defamation Act and the rejection of the tendency test in relation to defamation and the reason for it.
Yes. Well, the 2013 Act shows a change in parliamentary policy compared to what it previously had been.
Yes, but yes, the reason for it was the need to avoid freedom of expression being unjustifiably impeded by actual threatened libel proceedings.
Yes.
It was a recognition that this was a problem. And I'm now looking at paragraph 100 of the case on page 88. It specifically recognised the disconnect between the tendency test and actual harm to reputation allowed trivial claims to proceed. I've given the citation there. And there was a particular problem in relation to trading corporations, who of course will be entitled to take advantage of the tendency test just as much as any other, just as much as an individual claimant. And what the Joint Committee said, cited at 100, it's unacceptable that corporations are able to silence critical reporting by threatening or starting libel claims where they know the publisher cannot afford to defend and where there's no realistic prospect of serious loss. That's the chilling effect. Media defence talk about the chilling effect on the individual defendant of actually being sued. The last case, the defamation case that this court heard, where myself and Mr. Price were also involved, Serafin Markiewicz, is going to the European Court of Human Rights on the whole issue of the libel chill. And the effect of somebody being sued in the media and publications list, if you don't have a huge amount of money, is essentially life-changing. And the evidence was that these people have just basically given up their newspaper for the stress and the cost risk of being faced with a CFA claimant with 80 premium. I mean, that's the reality of the environment. It is a life-changing event. And when it talks about mental distress consequent on a full statement, I mean, the mental distress of being a defendant is immense unless you are totally protected on costs, which many defendants are. That's what gives rise to the chilling effect. You basically pull something, or you settle with an apology because you can't afford to fight it, or because there's an uncertainty of outcome, and that's a risk you just don't take. I mean, that is evidenced. That was the reason the Parliament acting, and I submit I can take all those points as given and apply them now, or ask this court to take them into account now in its interpretation of Section 3. So it's the effect on the individual, it's the effect just of an environment where this country is perceived as being a good place to come and sue if you want to restrain a problematic publication. And
myself, I don't see much fault in the point that you shouldn't be allowed to, that you should be allowed to make malicious statements on the basis that otherwise it might put off people who make non-malicious statements.
Well, you're not allowed. I mean, well, the chilling effect works on two levels. Chilling effect works on the existence of the laws, and that they impact on speech which is true, which is non-malicious. That's recognised as a factor, and even the Court of Appeal recognised that as a factor, although they played it down. I mean,
your more persuasive point, to my mind at least, is the fact there's no justification, countervailing justification, because
yeah.
Do you really have a right that people don't say false things about you that hasn't caused you any harm?
Yeah, well, that's the micro.
I mean, that's all. Somebody says something untrue maliciously about me, it doesn't do me any harm, but I can go off and successfully win a lawsuit on the other side's case, and that is quite a... It's hard to see why that should be.
Yes, and there is a case of TET in the European Court of Human Rights where a similar case to this in terms of, it was called slanderous denunciation, where there was a domestic finding that the defendant was false and malicious, but there was a violation on the basis that it wasn't a proportionate restriction, in part because it actually hadn't had any effect.
Particularly because we're postulating here a statement which is not defamatory. So it's not damaging to reputation.
Yes.
It's just untrue and malicious, but actually has caused no harm to reputation or anything else.
Yes.
But the respondents say, oh, well, nevertheless, you can win the lawsuit even though you only get nominal damages. But your point is, well, why should you win the lawsuit?
TET is cited by Media Defence. It is in the bundle, but it's in French, and the translation is not official. But can get, I suppose, if the court's interested in this, I could get an official translation and supply it after.
Well, if you can you give us a reference to the case?
Yes.
And we may be able to get by on our French.
Yes, it's 1729. I can go through the facts if that would assist.
We've got 1729.
It's in English.
Is it in English?
Yes, this is it's a machine translation.
Oh, I see. I see. Well, all right.
Yeah. It's TET. It's coming across as head case. And So the domestic proceedings were a criminal conviction for slanderous denunciation. Except this was criminal, that sometimes makes a difference, but actually, in practice, the harm caused to a defendant by losing a civil claim in the media communications list is far greater than the €2 or €3,000 fine that they get from a criminal case. So it's an open letter addressed to the President of the Financial Markets Authority, which criticised the company, yes, for providing false or misleading information in the context of IPO procedure. So publication to this authority with a request for prosecution. It related to the construction of a new football stadium for Olympique Lyonnais. You can see that from paragraph 5. You can also see from paragraph 12 that this letter that was sent to the prosecutor was also made public at a press conference, so there was wider publication. The paragraph 18 records that there was a tort fine of €3,000 and some other damage payments amounting to around €8,000. You can see the elements of the offence in paragraph 27 on page 1737. Reference to known to be totally or partially inaccurate.
Which
paragraph?
Paragraph 27, page 1737. I should add, it's possible that this offence could engage other aspects of Article 10.2, including sort of administration of justice restrictions on Article 10, not just the rights of others, because it's got to go to an officer of justice or administrative or judicial police and ask them to do something. However, you can see from paragraph 36 on 1739 that the legitimate aim was said to be the protection of the reputational rights of the OL Group or its president. And you can see that the applicant in the Strasbourg court relied on the absence of consequence. In opposition to that, the government relied on the wide media coverage given to the letter. That's the last sentence of 41. Probably don't need to go into the facts any further, but you can see in the submissions on page 1741 at paragraph 46, the reliance on malice by the government as justifying the restriction. And what the court did in France was to just focus on the constituent elements of this particular crime of slanderous denunciation without applying a proportionality test of where that led in the round and balancing in Article 10. And in my submission, the reasoning that one sees at 57 to 69, which led to the finding of a violation, is relevant to the issues on this in this case. It's quite lengthy, but
what are the highlights do you want to refer us to?
Okay, the highlights, paragraph 57, second line, they just looked into whether the elements of the tort or the criminal offence were made out without taking into account the applicant's right to freedom of expression. Paragraph 59, they ruled that it was a necessary breach of the duties and responsibilities inherent in the exercise of freedom of expression because the comments constituted slanderous denunciation. That of itself was sufficient. But the court said that you had to consider the circumstances of the case. Proportionality has to be assessed in that context. And when you assess it in that context, one of the factors to be taken into account is that at paragraph 62. That it didn't have any effect. Other factors were relied on. But the analogy that I draw is that you can't just say, oh, this person was malicious and it's got a tendency to cause loss. You have to actually look to see whether loss has been caused to justify the interference, because the right of the claimant's not engaged without that, so there's nothing to balance out the interference. It's not just a question of saying we don't give protection to people who are malicious. So this case was actually relied on by media defence. It's not in my case, but it seems to have some resonance to this case. And it also chimes in with the case of Denisov, which I don't need to go to, which was also cited by media defence and featured in this court's judgment in ZXC and Bloomberg, talking about the need to establish by evidence if there is a right the claimant relies on, in that case, engagement with private life, which clearly arose on the facts of that case.
This is Denisov, did you say?
Denisov, yes. That, again, forgive me, it's not in my case, but it's cited in media defence. It's also cited in ZXC, my Lord Hamlin's judgment in that, and the need for convincing evidence for engagement of a right of the claimant. And of course, the convincing evidence must be in relation to the context. That was a privacy right. He was clearly engaged on that case. And if we're talking...
What case, sorry? No idea what case you're talking about.
ZXC.
ZXC?
Yeah.
Is that a case?
Denisov, it failed on Denisov, but the ZXC is in the bundle. Yes, that's relied on for the threshold of seriousness. I can go to it for its analysis of Denisov.
Or is that the Bloomberg case?
The Bloomberg case analyses Denisov. So I was saying that...
Yes, so the two cases you're talking about are Denisov
yes.
and Bloomberg.
Yeah. Both are in the bundle. Denisov is cited by the media defence, but not in my case.
I got that.
ZXC and Bloomberg is cited in the case as authority for a threshold of seriousness, but not. I haven't specifically dealt with the issue of how the threshold of seriousness is to be satisfied. But Denisov says that you need to satisfy it by evidence of an infringement of the right. And when we are talking about an economic tort, then the infringement of the right, which has to be a property right, would have to be based on the existence of some loss. If there's no evidence of some loss, then it's not engaged. Therefore, that leads back to the need to consider the reality at trial as to what's happened and dovetails with all the other submissions. So my point is that all of it dovetails, and it dovetails to a historic test at trial to ask whether there has been any loss.
Yes, your argument is notwithstanding slander, Tet is authority for the fact that Article 10 is engaged. But Tet in France was a case where you were dealing with a political activist taking up the cudgels in a subject of general interest, which might be said to be quite close to the heart of an Article 10
Yes.
protection.
Yes.
Here we're dealing with a case about a dispute between two individuals and in a commercial context and a possible pursuit of revenge. by an employee against a former employer.
Yes.
Slightly different context, but you say Article 10 is still engaged.
Yes, because there has to be a single test for Section 3. It can't vary depending on the nature of the information. As I submitted right at the beginning, it's capable of covering a wide variety of information, and there's plenty of cases that do involve political information, and the Section 3 test has to apply consistency. We can't possibly have a Section 3 test that varies according to the nature of the information and how protected it is. So TET shows that you can be malicious. You can be malicious, but there's still a proportionality test that's necessary. You can't just say you're fair game because you're malicious. Given that this issue is dealt with quite fully in the case, and I've put all the references in, and you have the intervention from media defence, I was proposing to use the last 25 minutes to deal with the interesting issue of distress damages absent proof of loss. So do forgive me, there's one final submission I need to make in relation to Article 10, which is how the HRA applies in practice, and that's set out in paragraphs 118 to 120 of the case on page 93. What you do is you look at the competing interpretations that you've got before you, and you ask, well, which is... You go for the historic test because it's the only one that's consistent with Article 10, and you don't. If it's a worry that the wording of the statute is calculated, you don't worry about it. It's perfectly permissible within Section 3 for it to be interpreted as is likely to have caused. So one doesn't need to resort to a rebuttable presumption. If that one doesn't run, then your competing tests are between the forward-looking test taking into account all relevant facts or the tendency test, and then you've got to plump for the forward-looking test taking into account all probative facts because that's less restrictive of freedom of expression, and there's no justification for the tendency test from an Article 10 standpoint. I move on to damages for distress absent financial loss. The effect of the Court of Appeal's judgment is that you can get potentially substantial damages in malicious falsehood on the basis of distress, even if you haven't suffered any loss. That seems to be stretching an economic tort way beyond any justifiable principle and is incoherent, I respectfully submit. What I've done in the case is I've set out a sort of series of negatives that there are no cases, and I haven't been corrected by the respondent that there are some cases. So I'm going to go through these what hasn't happened ever before. But of course we come back in paragraph so we start in paragraph 122 with the nature of distress damages. I mean, it's not damage, it's not material damage, it's not a psychiatric injury. Yes, perhaps it should be compensated on, and various torts do provide for recovery for distress if it's consequential on the tortious act and it relates to the interest protected by the tort. But the fact is, it's a transient, it's a less significant type of mental injury. It needs to be kept within proper bounds. It needs to have a meaningful substantiality threshold, and the reality is it's quite easy to say I've been terribly upset and very difficult to disprove. It can't simply be because the tortious act has upset the defendant. There has to be a relation to the damage that's been caused, that's caused the upset.
Well, it all comes back, doesn't it, to the inherent nature of the tort, yes. The interest protected.
Yes.
I mean, do you have an interest that needs protecting, that people shouldn't maliciously say false things about you that cause you no harm to your reputation or otherwise? The fact that that might be hurtful when you find out about it, is that enough to go up to the courts?
No.
And you say no because the essential nature of the tort is it's got to cause you some loss.
Yes.
Off the back of that, you can get some distress as well.
Yes, it's really it. And there has to be some link. I mean, yes, if the purpose of the tort in part is to compensate for distress, you're straight in there. You don't have to worry about perhaps other loss. You could perhaps justify it. But it generally has to be contingent on the harm that the tort exists to protect. And that's all the statements of principle that I've made. It's particularly problematic when you've got a claim in defamation and a claim in malicious falsehood, because we focused on malicious falsehood, but the reality is at trial, you can see from the proceeding at trial, that libel was the first claim. This case was all about this publication having gone to 100 clients of the second appellant. I mean, there was no evidence of this, but the case seemed to proceed on this basis, and it was rejected at trial. And the respondent's case on distress was all about the reputational effects for her of this going throughout the industry. So there wasn't even an evidential basis for it. And although the judge said he would have potentially awarded some damages for distress, he recognised specifically in the grant of permission to appeal that was subject to a question of an evidential basis and an entitlement at law. And that qualification hasn't appeared, I think, in the Court of Appeal's judgment or the respondent's case. You have the permission to appeal reasons in the bundle. I think in the part 1 of the appendix has them. But anyway, the point is made. The judge recognised that this was all subject to argument. But how do you extricate where a defamation case has failed because of an absence of serious harm? How do you extricate the element of distress that's relevant to financial loss? And then what if there's no financial loss? I come back to the point made by my Lord Legate in the Marathon case. You don't get compensation for a risk of injury that doesn't materialise. To get distress damages in malicious falsehood, they at least have to be related to the loss. I mean, it would at least have to be, if they're allowed on the basis of a belief of loss, which they can't be, it would have to be, I'm worried that I've suffered loss, and maybe that's on a misconception. I mean, there's fundamental reasons not to allow recovery of distress damages based on a misconception, but the evidence in this case was completely lacking as to distress damages consequential on an inherent tendency to cause loss, which was the basis that the Court of Appeal said that they could be recovered. There was 2 publications complained of. I'm now looking at the final part of my case, which is the application of the relevant principles to the facts. It's on page 99, paragraphs 143 to 149. So if one assumes for the moment...
At the time that the 1952 Act was passed, libel was actionable per se.
Yes.
So, in that sense, I'm assuming that at that point in time, without showing any financial loss had been caused, you would be entitled under a claim for libel to mental distress damages.
Yes. Absent financial loss, yes.
Yeah. So one might say, what's the difficulty with doing that here? I think you set this up as, there's often an interplay with libel, and how would this work?
Yeah, how would you extricate it? But I think with respect, it's not a question of financial loss. It's a question of injury to reputation, which is the interest that the tort protects. So the analysis would be, you have injury to reputation, you have distress consequential on it, and that same reasoning would say you have economic loss, and you have distress consequential on it, and it can be recoverable. But
your fundamental point in the whole case is that people don't have an interest to protect, just simply by something false.
Yeah.
Knowingly false being said about them, if it neither harms their reputation nor causes them any financial loss.
Yes.
And the law, if it were to treat it as being an interest, there's some interest there, that would open up a very wide door indeed.
Yes.
So, well, it may have caused me no harm that I could point to at all, the fact you said something untrue, new about me, but I find it terribly upsetting to find out that you did.
Yes. I think my learned friend may say, well, you've got the Jameel abuse of process jurisdiction, but that's not going to work because Parliament has given you a right to sue and you're upset. Why can't you, if that's the law, why shouldn't you proceed with that? Jameel's just not going to, it's not an answer to an interpretation, a principled and coherent interpretation of Section 3 or indeed the whole damage element of malicious falsehood. But just finding...
Lord Leggett's point, I think, is simply that in case of defamation, you have an interest to protect in reputation, and distress gets tied onto that.
Yes.
In relation to malicious falsehood, you say there has to be loss before you can get distress. Yes. It's as simple as that.
It's simple. And the brief mention of the Scottish Act, the explanatory notes do specifically say that it's only available, damages for distress is a specific statutory provision, only available if there's economic loss.
Are they in our, is that in our bundle, the explanatory notes?
Yeah.
Just the reference.
I think it's paragraph, it's not in my case, so if I might just go to it. The explanatory notes are at 537.
Well, I'm not sure the explanatory notes, which may not be admissible anyway, the Scottish legislation massively postdates this Act, sheds much light on it.
Well, I mean, just for the reference, it's page 541, paragraph 121. But yes, I mean...
There's case law, isn't there, that enunciates the principle that damages for distress are only available off the back of the primary infringement.
And just finally on the facts, so the court says you can have damages for distress based on an inherent tendency to cause loss because it's distressing if you're the subject of an allegation which has an inherent tendency to cause loss. But it didn't really have any focus to the specific facts. Paragraph 79 on page 174, I've set it out in the case at paragraph 148. On page 100, the court held neither the claimant nor the defendant knew, as the judge later found, what was inherently likely would not in fact come to pass. The fact this later emerged and the claimant came to know about it would limit but not extinguish her claim. But it's not quite clear what that means, certainly in relation to Lingenfelder, because the judge's findings of fact were that straight away Lingenfelder knew that the allegation was false, he was 100% behind it, and anyway, he didn't want her to compete with the second appellant's clients. As far as Butler is concerned, perhaps it's suggesting that maybe the respondent didn't know that Butler had taken against her, but there was no evidence that the loss of Butler was going to have any particular financial impact on her and that she was concerned about that. It wasn't the subject of it.
The suggestion is that you should get compensation for distress, being upset because you fear that you might have suffered harm when in fact you didn't.
Yes. So unless I can be of any assistance, those are my submissions. Just on Musk, Mr. Jonathan Price seems to have solved.
The question arose whether in Musk any due diligence was undertaken in response to the statements complained of. It's a small point. The court didn't deal with it because the finding in Musk was that the court, it's at paragraph 611, we don't have the whole judgment in the bundle, but the court didn't find the statements were made as alleged in any event. So in fact, when it went on to deal with damages, it did so obiter and only in deference to the submissions that had been made and the evidence that had been led in relation to them. So the statements were not found to have been made, and therefore the issues of defamation and malicious falsehood came to a grinding halt at that stage.
Thank you, Mr. Price. Any questions?
No.
speak
I don't know. I mean, I'm only reminded that you said you were going to take us to what Sir Donald Nichols said in Joyce, but I mean, I'm not saying you necessarily should, but I just wanted to remind you, you said you were going to go to that. If you did want to, then fine. If you don't worry.
Well, no, I mean, perhaps I was relying on the indication given by my Lord Legate about this, the point was clear from the case law.
I wasn't suggesting that that was a reason not to show us the case.
But, I mean, actually, that was my other question.
I didn't say it was clear. I just said that rather than what I meant to say was rather than when there are some cases apparently which address this, it's better to look at the cases than at the explanatory notes to the Scottish Bill.
So that's my misunderstanding.
Were you, in terms of case law, were you relying principally on Lord Devlin and Brooks and Barnard?
There's partly that as a general principle.
Just briefly, I mean, what is the case law you rely on? And is there anything you want to say about Joyce? That was really...
Yes. Can I... Well, I've got another 15 minutes or so I think I can do that within this time.
I'm not necessarily inviting you to take us to any particular case law, but just to identify which cases you rely on in that respect.
Yes. Well, I rely on Lord Devlin and Brooks and Barnard for the principle set out in paragraph 125 of the case on page 94, that even where the damages are at large in an economic tort, it's well established that any non-pecuniary element must be based on the pecuniary loss. And that's a consistent principle. And there are no cases where you've had distress damages which aren't based on the economic loss, so far as I'm aware. That was the gauntlet that I threw down, and it hasn't been picked up.
Okay, I follow that, yes.
As far as the authorities are concerned, there are specific authorities on this issue, although none involving where there's been... I mean, Fielding perhaps, yes. Fielding was a blanket rule. That's cited at 133 of the case on page 96. Lord Devlin says you just can't get damages for injury to feelings in malicious falsehood. But I'm accepting, consistent with what's said by Lord Devlin in Brooks and Barnard, that you can. And, of course, Sir Donald Nichols, Vice-Chancellor, in a lengthy obiter judgment, took a different view, although he recognised there were some conceptual problems. I'm going to go to Joyce as the last case, but if I can just jump forward to Codaparast. Now, that was a case where mental damage, distress damages were recoverable, but as I say in paragraph 138 of the case, that it's of little assistance because here the injury was directly connected with the serious losses and harms caused by the falsehood, which are referred to in footnote 99. It was an awful case where the defendant had circulated within the Iranian community a mock-up photograph which suggested that the plaintiff was a pornographic model. He'd done it for revenge purposes. It was a former relationship. And this had caused her to be deprived of employment in the Iranian community by any member of the community and derived employment which she greatly enjoyed. And actually, in terms of the question about calculating damage on Section 3, there was an attempt in that case on the damage element to work out what the loss of her employment would end up amounting to, by analogy with personal injury. So it's interesting for that point, but it doesn't really help us on the specific issue in this case. What helps us on the specific issue in this case is the judgment of Sir Donald Nichols in Joyce and Sen Gupta. I've set it out at length in the case, but perhaps since we have a little time, I will go to the judgment itself, which is on page 290 of the authorities bundle. I previously referred to the facts. The analysis on the availability of distress damages starts at bundle page 300, D. And perhaps the relevant, we can start at G, with one exception. There's no authority dealing expressly with the question whether, if pecuniary loss is established, the plaintiff can also recover damages for anxiety and distress. The authorities are silent on this point. Thus, so far as the report decisions go, they show that an award of parasitic damages under this head has never been made for malicious falsehood. So you'll see as we go through this repeated connection of the distress to the financial loss. And the conclusion that's reached in the last paragraph is that it would tend to suggest that these damages are not available, and it is considered to be manifestly unsatisfactory and unjust. Why? Well, the examples given there of a businessman suffers severe financial loss and then suffers acute anxiety and distress. And the question is asked, is it right that he can't recover for it? And the sentence, last sentence of that first paragraph is clearly relevant. Although injury to feelings alone will not found a cause of action in malicious falsehood, ought not the law to take such injury into account when it is connected with the financial damage inflicted by the falsehood? And then he looks to analogies with other torts where proof of damage is an essential ingredient, so other than malicious falsehood. And then there's a citation from Pratt and Quinn that we've got those cases in the bundle. And clearly there was an element of distress damage award in those cases, but there had clearly been serious losses. The citation from Lynch and Knight, which is a slander case, again linking the material damage to the pain and anxiety, material damage being special damage there. The recognition in the next paragraph that the point bristles with problems. And one of those problems is the difficulty of dealing with injury to reputation. And that paragraph also refers to the need for coherency. That's important in my respectful submission in the law relating to damages. So the analysis goes on until the end of the judgment. But the contemplation here clearly is mental distress, which is consequential on damage, financial loss. And it's also dealt with in the judgment of Sir Michael Kerr, but I don't think it's as helpful as the judgment of Sir Donald Nichols, Vice-Chancellor, that it's there. I think the respondent refers to it, but it sort of proceeds on the basis of aggravated damages. That's not very helpful in my submission. I mean, that we should call distress damages by their true name. And if they're not available directly, they can't be available through the back door as aggravation because of the way that the litigation has been conducted by the defendant. There are no other cases which I think bear on this point, certainly not in malicious falsehood. But we come back to the statement in Marathon that one doesn't get compensation for the risk of something that doesn't materialise. And that equally applies to, or perhaps more strongly applies to, distress damages. So, unless I can be of any further assistance, those are my submissions.
Mr. Price, thank you very much. I suspect you'll be content to leave your opening till tomorrow? Or
more than content.
More than content. I think that's what we'll do, given that you have confined your submissions to 3 hours. The court will now adjourn.